Hi everyone, it's Paul Tilley. Welcome back. Today in LW1230, we're going to be looking at the first part of Unit 2, which is Tort Law in Canada. In this particular section, I'm going to be looking at some common intentional and maybe unintentional torts and explain what they are, what they entail, and common defenses for them. So tort is a very interesting aspect of law. And from a business point of view, tort is extremely important because businesses get sued a lot for what we call tortious actions. And what a tort is, effectively, it's a wrong, some sort of a wrong where we have to think about we've done something unintentionally or we've done something intentionally and someone has been negatively affected by that. Okay, so it doesn't need intention. That's a critical thing. Anyway, so this whole unit, we're going to be looking at this whole concept of tort and how tort is managed. And I'll just say to you that it rolls over several chapters. If you look in the textbook is chapters 4, 5, and 6 of the textbook that we're using. Every single textbook, if you don't have exactly that textbook or an earlier edition of it, every single textbook covers tort. Every first year law textbook, and the same material you will find in all textbooks. So I'm not going to get too hung up on which textbook you have. I just need you to make sure that you look at the tort section. As well, as I say, I'm constantly adding to the Unit 2 tort law, so I want you to take a look at that too. So in this particular unit, as I say, we're talking about tort, but in a broader sense, or more specifically, we're talking about intentional torts, and intentional torts include assault and battery, false imprisonment, trespass, nuisance, defamation, and negligence. And we'll look at those in great detail. Now, for every tort, there is defenses, and we need to think about what are some of the defenses that we as an organization who's being sued may look to in order to preserve ourselves in the case of a wrongful action. So we'll take a look at that. We're going to look at this whole concept of cause too, causation, and what exactly should we do in terms of what exactly should we be responsible for in terms of the cause. And we've got this concept of duty of care and standard of care. The duty of care is kind of a broad brush umbrella duty, whereas a standard of care is the measure of how much of a duty we owe. So we're going to look at that. We're going to look at the concept of foreseeability and how that comes into it. We're also going to look at it from a employment point of view, this concept of vicarious liability, which is a liability that your employer carries over you in terms of when you do something wrong at work. And we're going to look at something called negligent misrepresentation. We're going to talk a lot about Donald Trump here. And we're going to look at occupier's liability, product liability, professional liability. Basically, that's scattered through the section. And we're going to look at, obviously, some tort cases. And there's been some great tort cases. So as I say, a tort is a wrongful act. And it's a wrongful act that has to result in an injury, okay? So it's only considered a tort if someone is hurt. So you just can't sue because you see it. You got to suffer from it. So that's one of the first tests is, did someone get hurt by this tort activity? And when we think about how they get hurt, we think about your person got hurt, or your property got hurt, or your reputation got hurt. Normally, that's what it falls under. Those are the three specific categories, and there are others as well. But generally, you're either personally hurt, physically hurt, your property, something you own, is hurt, or your reputation is hurt. And the compensation for tort, what you get out of it, someone who's wronged gets out of it, is compensation, money, something to do with some recompense that relates to money. Now, the injured party sues you. If you're the person who's being sued, or you're the wrongdoer in this case, they're going to be looking for money They're not going to be looking for anything else. There's no jail or anything like that. It's going to cost you money. And this is what you normally have insurance to cover off. So normally, as I say, a tort is considered a wrong, so you're looking for money or some sort of redress. However, it could fall over on the criminal side as well. In our society, the question is society damaged by what you do? And if it is, we could say that the tort not only is a tort against an individual, but it's a tort against society. And torts against society would be considered a criminal act. So the state could get involved in a tort. Now, and we also talk about employers and employees. As you become an employee of a firm, you are what is said their agent. So, for example, I'm an agent of the College of North Atlantic. Okay, they pay me, and I am the face and eyes of the College of North Atlantic. So, let's say I did something wrong here, something that was tortious, where you are injured as a student, person, property, reputation, or the like. Okay, so in this particular instance, you would sue me, but you would also sue the College of North Atlantic because I am an employee of the college. The college, because of this concept of vicarious liability, the college, provided that I did not act out of the realm of what I'm supposed to do, okay? The college will be responsible. So that's hard to do in my position, but let's assume that you're here and we're online and your eyes are damaged because you're looking at a computer screen or you're looking at me. Well, you could argue that that's a direct result of the college and the work that we did. And in that case, the tortious activity would be, you'd sue me, but the college would ultimately pay, not me, because I'm just an employee of the college. Now, if I did something, the college may argue that I did something outside of the realm of my work. I came up and broke into your house, okay? That's not within the realm of my work. And the college will say, we're not liable for that because that is not really a work-related liability. So vicarious liability only applies if you are working for the company and you're operating within the work. Like the college is not a good example, but if you're a driver for Day and Ross and you have an accident, you're working within the Day and Ross structure. Ultimately, the insurance or the liability would fall to Day and Ross, not you. You had an accident, provided that you were operating under the conditions of the company and your normal business activities. The company would accept the liability for that. And the last thing that's listed there is probably the most important one, is that torts may be intentional or unintentional. The word intentional means that I took an effort. If I'm the one that damages you, I took an effort to damage you. I thought about it, I acted on it, and I did it. So that's what we know by an intentional tort. An unintentional tort is I had no idea what I was going to do hurt you. It did hurt you. You were damaged because of it. Okay? That creates two different scenarios, one of which I had intention, which is I purposely did it. You could see that being somewhat criminal if you were hurt, right? So an intentional tort carries a lot more weight in terms of damages or potential for liability, not only civil but criminal, than an unintentional tort. If I accidentally did something that hurt you, true enough, I did hurt you, no question about it. I did commit a tort, but I didn't do it intentionally, and the damages would not be as great on me. Okay. This issue of the tort versus crime or tort versus criminal activity really causes a lot of confusion for people because a lot of torts do cross over that line. So here's the general, this little graphic that was in your textbook is really a good general kind of decider on whether or not it falls into the criminal realm. So Joe, while intoxicated, accidentally hits Sam with his car. Okay. So drunk driving is a criminal act. It is a crime. So in one respect, you would be sentenced by the judge criminally And in that particular instance, the state, which is the crown, or the federal government, the provincial government, the governments would bring you to trial, and there they would have to provide what's called a proof beyond a reasonable doubt. Okay, so there's a much higher standard there, beyond reasonable doubt. If they had a photograph of you driving the car and involved in the accident, a film photograph, that would give proof beyond a reasonable doubt, and you would be convicted. And the punishment would normally be prison in this case, and the fine could be a fine. You could lose you would lose your license. These sorts of things. Okay, that's one route. The other route is let's assume that I'm the one that's drunk and I hit you. The victim, you, could sue me in civil court as a tort because I did not bring a standard of care to my actions. I should not have been driving while I was drunk. So the proof level that you need to provide there is not nearly as much as it was in criminal court. And the compensation would be dollars. You would sue me for money. I'm going to bring you back. Some of you will remember this, some of you may not, about the O.J. Simpson trial. Now, it was down in the United States, not the same jurisdiction. I got to be careful here. But if O.J. was in Canada, the same thing would have happened. Back in I believe it was the 90s, O.J.'s wife was killed, and he was brought to trial for killing her. So it went to criminal court. The criminal court needed proof beyond a reasonable doubt. This was in the United States, and it did not find him guilty. He was not found guilty because you're innocent until proven guilty. They could not provide enough evidence to bring it to that standard beyond a reasonable doubt. However, the family of the wife brought him to civil court and sued him, and they won because the proof upon balance of probabilities is a lower standard, and they got compensation from O.J.'s estate for her death, which seems kind of odd. In one court you wouldn't get charged, and in the next court you did. But it has to do with this different levels of proof that has to be put in place. So first we're looking at this issue of intentional torts, okay? What defines an intentional tort? An intentional tort must be deliberate and calculated. So you got to have some planning behind it. It has to be purposeful. You have to really demonstrate that in order to prove a intentional tort. There's no need to act for the act to be actually committed. Rather, it's sufficient to prove that there was an intent to commit it. So let's assume, for example, you found out that I had planned to smack into your car and damage it just because. All you needed to do was to prove that I was planning to do that. Now, again, you need to be able to prove it, which is a little bit challenging, but the proof levels, balance of probabilities that I was going to commit a crime. Your car may not have suffered any damage. It's just you felt that it would have. Now, this is a little bit of a gray area for a lot of the courts, because proving something that didn't really happen is hard to do. Okay. Normally, when you think about an intentional tort, something actually did happen. So there's no need for the action actually be committed. In most cases, the action is committed in order to prove that sufficiently. Now, if the conduct was accidental, the tort would be considered negligent. So in this case, let's assume that I didn't mean to bump into your car. I had no intention at all, but I did. And you would have your car damaged, and ultimately I would be negligent for that. In other words, my insurance company, or if I didn't have insurance, I would be responsible for fixing your car, to bringing you back to the standard you were before the accident. Here are some common intentional torts. Now, these are common as much in business law as anything else, okay? They're not the only ones, but these are the common ones from a business law point of view, okay? So the first one is this concept of assault and battery. And these are two related but different terms. Assault means I threaten you, I do something with you to make you feel that you're in danger. I don't need to lay a finger on you. Battery is when I actually lay a finger on you, okay? Battery involves physical touching, physical hitting, physical damage to your property or person. Assault is just a threat, similar to before. So we'll look at, I have it laid out more in the next slides. There's another type of tort that occurs in business a fair bit, and that's false imprisonment. False imprisonment from a business point of view is usually occurring in shoplifting cases where someone is accused of shoplifting and they're held in some sort of holding area until the police come, okay? You got to be very careful with false imprisonment, because false imprisonment is a tort where if you feel that you are not free to do what you want to do, you could argue that you were falsely imprisoned and sue someone in tort for that. That's equally true for people who were accused of shoplifting. Unless there is some proof, some blatant proof, false imprisonment is a potential threat that store owners face if they try to hold someone until the police come. Trespass is another common one. Trespass means that you're somewhere you shouldn't be. You're on someone's private property and you go and you're on their property doing something on it. Now, you could be purposely there or you could be accidentally there. But the fact of the matter is you're on their property. Nuisance. This is a common one. A nuisance means that you are disturbing the other person's right to enjoyment of peace and quiet. I had many nuisances in university when I lived in residence, right next to me playing loud music. That would be considered a nuisance. And theoretically, that is a tort, and you could sue someone for nuisance. Now,
what if some like in like 1 o'clock in the morning, some guy just run down the street in a loud ass car?
Yeah, you could theoretically. You have to prove that. Going back to the start of it, you have to prove that you were hurt or damaged by it in some way or another, okay? I don't know if waking up would be considered hurt or damaged. Now, if some guy came down the street and tore down your fence or flung rocks at your house, which caused damage to your house, certainly, yes. This issue of nuisance came up here on, as I think most of you saw, on New Year's night and the days after. There were fireworks going on constantly, and we had some issues I know I had brought to the town's attention with regards to the nuisance of fireworks going off at every hour of the day and night for 3 or 4 days. And this is something that we're grappling with now in council, because there is a lot of arguments out there that these nuisances cause people harm. You know, their dogs ran away, or you know, their property, the right to freedom and enjoyment of their property was upset. So nuisance comes into play as a problem. Now in business, people who live next to the Come By Chance refinery have argued that there's nuisance living next to the refinery because of smoke and the smell. You know what? Where does it become damaging to the person and individual? Well, there's been many cases on that. You know, to proving that site, that industrial site, was damaging to you. It can be challenging in court, particularly seeing that you had to prove that your cancer was caused by, your deafness was caused by, these sorts of things. And that there's been many court cases on that.
But like that refinery was probably there before you moved in, so you should have known ahead of time that you were going to be living next to a refinery.
Yeah, you're getting some of the defenses now, and this is true. These organizations or for all of these that we're dealing with, there are defenses for them, and we're going to look at the defenses, and that would be one for the refineries. Say, you know, the standard was that there was noise and smoke before you ever moved in, so you can't blame me now. That sort of thing. We also have defamation. Defamation occurs a lot in business, where let's say I say something bad about you, or I write something bad about you. Libel is when I say something bad about you. Slander is when I write something bad about you, okay? Now, defamation is, again, a common one that ends up in court, and the courts will look at this and they'll ask themselves, was anybody hurt? What was the measure of that hurt? Very hard to determine in most cases. So courts are often faced with a problem. Saying it, the libel one, that's harder to prove, because saying it, unless it was recorded or something like that, very little tangible evidence. The good thing about something that's written is there is tangible evidence. And from the point of view of the person who is slandered, it's easier to prove. And from the point of view of the person who is being accused of slander, it just proves that you should be careful what you write, because it will come back to haunt you if it's written down, for example, in an email, these sorts of things that can get distributed. Then it becomes problematic. And then we got the issue of negligence, and negligence is kind of an issue in and of itself that we'll be looking at. Negligence is a bit of a challenging one, because it really depends on a whole bunch of factors if someone is negligent, okay? You got to look at the someone. Let's say, for example, you were in my house and you fell down and you had a heart attack and I didn't do anything, okay? You could sue me for negligence. But am I a doctor? No. Do I know what a heart attack looks like, feels like? Not necessarily. What obligations do I have to you? These sorts of things. So negligence brings with it all kinds of challenges that we need to consider in business, particularly from a business's point of view. What is the duty? What is the duty? So we're going to look at that. Okay, let's look at these in turn here. Now, the first one is the assault and battery. Let's look at that a little bit more closely. So an assault is defined as an intentional threat of immediate harm towards a person from the victim's point of view, okay? So a threat of immediate harm. Key word there is immediate. It's, you know, I'm gonna beat you up, buddy, doesn't really say or imply that I'm gonna do it now. You know, you have to feel as if there is a threat of immediate harm at a point in time in order to bring an assault charge. If you've seen the news and you've been following what's on the go in Washington a couple weeks ago when the Capitol rioters went in, again, it's in the United States, not our jurisdiction. I'm just using this as an example. But again, same types of laws exist in the United States. So people invaded, I'll use the word invaded, the Senate down there. And, you know, it is a public building. You could argue, oh, yeah, well, it's a public building. People are allowed in. They're not allowed in the way that they went in. They basically broke in. They didn't go through the metal detectors. You know, there was all kinds of, I think you could easily argue that those people were in there with an intention of threat. Okay? So anyone who wanted to sue either one of them could say there was an intentional threat, and the very fact that they were in there then, you could argue that that's a threat of immediate harm. So I could see some of the senators arguing that, yeah, they were assaulted. They were assaulted at that point in time, and that would hold true. To be an assault, it must be physically possible to carry out the assault. So again, you know, were the senators and the people who came and invaded in physical proximity to one another? Yes, they were. You got to be able to carry it out. Some of them had guns. Some of them had, weapons. Some of them had hockey sticks, anything. Bats. You could argue that, yes, there was a physical possibility. I'm on the other side of this computer here now, and you're on the other side of your computer. There's no physical way that I can say, I'm going to punch you in the nose. I cannot physically get to you. So there's no way that I could assault you here. Now, there is no need for the assault to be harmful. It must only be unwanted. And this is where we get into sexual assault, for example. It may not have harmed someone, but from their perspective, it did, and it was unwanted. So again, sexual assault is a form of assault, and the critical issue is, was it wanted or unwanted? And if it was unwanted, it was an assault. And the assault doesn't require the physical contact, okay? Keep in mind that I'm threatening to do something, and you feel that that is imminent. I physically am close enough to you to do that sort of thing. If you can argue to a court that you felt threatened because of that assault, and that the court looks at it and says, okay, there was a physical ability for that to happen, that there was the ability for physical contact, the court would rule, yeah, that you were assaulted. Again, it's from your perspective, not mine. You're the one who assumes that you were assaulted, right? You're the one who decides if an assault took place. The battery issue, which is the higher level, again, assault is one level. Battery takes it to a totally different level where I actually hit you, I cause damage, I do something. So battery occurs when contact is made. And this is when it starts crossing the criminal line. You're not allowed to go around punching people out. It is a criminal act. So it crosses. We looked at this idea of it crossing here. If, for example, someone gets hit, then that is a state offense, and as a result, there is a punishment that the state would offer there in the form of a fine or prison. The proof has to be much higher. The standard of proof is much higher, but all the same, it is clear there that if someone got hit and they got a black eye, that the reasonable doubt issue is not really that hard to prove. Okay, so there are a bunch of defenses there. The first defense. So you have accused me now of assaulting you and battering you, okay? So I threatened you and I hit you. The issue is, let's assume that the context that occurred in was a boxing ring. And you're in the boxing ring and you know full well what the boxing ring is. We're at a boxing match. It is a competition that we're involved in. And I punch you. And you sue me for assault and battery. I, being the one who's being sued, is going to argue, no, we're in boxing. Boxing involves punching people. It involves intentionally punching people in order to win the contest. We have gloves on and these sorts of things to help us. But the fact of the matter is, you knew full well that when you go into a boxing ring, you may get punched. The judge would look at that and say, yeah, that's right. There is reasonable consent. Any of you people who are hockey fans will remember, I cannot remember the hockey player's name because I'm not that much of a hockey fan, but there was a case here about 10 years ago where a guy on the opposing team came over and hit a guy and cut his jugular with his skate. Okay, so it was a.
Oh, I remember hearing about that.
Yes, it was a very, very bad situation on the ice. Okay, and the question in law was this assault and battery? It went to court, and Marty, I forget, it wasn't Marty McSorley. I forget the guy's name. Anyway, the question was, look, we're in a game of hockey. The game of hockey is physical. skates involved, there is sticks involved, checking is allowed, you know, it's all there. Was there consent? Was there consent for that hockey player who accidentally or had his throat cut? The judge ruled, when the judge looked at this and all of the facts of the case, the judge ruled that the man, the guy that was the accused, did indeed use excessive force and had intention to hurt the other guy. So the consent argument was not successful in that particular case because the NHL have certain rules of play, and that even though checking is allowed, it's not bashing the other guy in the head. Okay, you can't go that far. There's a length that you can go, but you can't go beyond that length. So the consent argument is useful, provided that you're within that reasonable limit. You know, if we're in a boxing match and someone takes out a gun and shoots the other person, no one consented to that. Okay, that wasn't the idea of boxing. Boxing involves using your fist in order to punch, not shooting someone. So consent is within the bounds of the normal operation. Now, consent in games of sport, such as hockey, soccer, all these games, there is a certain degree of physical contact. And when anyone is involved in those games, you would have some sort of implied consent that if someone is hurt, that is a possibility under the concept of the game. We just can't say that, no, if something bad happens, the player is responsible. Okay, but if the player goes beyond what is normally acceptable in the game, no one consented to that. So that's been tested in court. Another important defense for assault and battery is self-defense. Oh, I got to be able to spell defense right. When we look at self-defense, this is again something that comes up a lot in cases of sexual assault and sexual violence. Okay, let's assume that the man is assault and battering the woman. The woman gets her hands on a knife and kills the guy. Okay, now, and many cases have hit the court like this. Okay, so the woman is being assaulted and battered, fears for her life. She, in turn, kills the perpetrator. It could be argued that that assault and battery, meaning that she sliced and diced him, was not acceptable. You know, she killed a guy. She killed a guy. Strictly, it's murder. And that has
self-defense, but it was excessive self-defense. So I think you would still get in trouble for that.
That's right. And how much is reasonable? The court is often asked to determine how much is reasonable. Now, in the case of sexual assault, if that woman can prove that there was a long history of abuse and that sort of thing, several people have been able to basically get away with murder because of that. They felt that they were in immediate danger and that self-defense, that level of self-defense was required. The question is, in all individual cases, we have to ask, how great should the self-defense be? And it should be limited to reasonable force in response to the situation. Okay? So if you feel that you are in imminent danger of being killed, murder or killing someone is a reasonable self-defense. If you
that's a very big issue in the United States.
Yeah,
stand your ground law.
Yeah, and in the U.S., this has come up, and there are some rules in the United States that are way out of whack. You know, someone trespasses, you can shoot them, and this sort of thing. It doesn't seem reasonable at all. But in Canada, we have to have a justifiable response. Okay, so effectively, the response can't be greater than the threat. This, I had a case there. Now it's getting older, but Gian Gomeshi was a CBC radio host on Q, and he was fired by the CBC because he was accused by a bunch of women of sexual assault. And he used he used the consent argument that these women agreed to being tied up. There was sadomasochism. It was all, they agreed to it. And, in some cases, they pled self-defense where they smacked him back and these sorts of things. This case was really a bit of a very public case 6 or 7 years ago, in which these two pieces came up in the arguments. Gameshi was found guilty. Okay, so that's, any questions on the assault one? That's a common one that appears in business and in tort. Another fairly common one is the false imprisonment. So false imprisonment is really an unlawful restraint where a person feels, and the critical word there is feels, that they are prevented from leaving. It includes physical restraint as well as when the victim thinks there's no option to leave. So if they lock you in a room, that's probably a better one, because the fact of the matter is you can't go, and it's cut and dry. The ones that's not cut and dry is when you get the sense that you can't leave. So you've been accused of shoplifting, you're brought into a back room of Walmart, and they say, sit there until the cops come. Okay? The question is, when does that become false imprisonment? So it occurs if you are arrested by a private citizen. So here's the critical thing. Private citizen when no crime has taken place. So let's assume that let's go back to Walmart now, and I'll be the perpetrator. Okay, I have my pockets full of my favorite candy that I just stole from Walmart. Okay, I'm sat there, and I'm thinking, I'm falsely imprisoned. I'm going to sue them for false imprisonment. The fact of the matter is, though, I did steal the candy. They are well within their rights to hold me if a crime has taken place. I did have the candy. You can see it in my pockets. No question about it. A crime did take place. In that case, I cannot argue false imprisonment. However, if they think that I took something, then I can argue false imprisonment. Now, the private citizen issue comes in here. Mall cops, as I refer to them, or security, mall security, are not police officers. They are, for the purposes of law, private citizens. They cannot arrest you. Okay, so police, however, the people who are designated as police officers, RCMP, Royal Newfoundland Constabulary, those people have the power to arrest, and they can withhold you. So false imprisonment only really occurs if somebody who does not have the right to arrest you arrests you. And we hear tell of a citizen's arrests and this sort of thing. You hear tell of that a bit. Yeah, you got to be careful with citizen's arrests, because unless it's absolutely positively for certain that that person committed whatever they're being accused of committing, you could be held liable for false imprisonment. Okay, so this is a big problem for stores. This is a huge problem for stores. They might know in their heart of hearts that that person has their pocket full of candy, but they need to be able to prove it. And so what stores have done lately is they have done a lot of work with regards to security cameras and the like, so they can prove it. Okay, the way the law is written, they have to be in a position to prove false imprisonment. Any questions on that? Trespass is another interesting tort. Trespass involves me, the perpetrator, on your property without permission. So trespass involves coming onto another's property without permission or authority. Now, this happens a fair bit. And it could happen intentionally or it could happen unintentionally. I could walk on your property and not even know it's your property and walk on your property. So theoretically, trespassing is pretty common. I could argue that, oh, I accidentally was on your property. It's not strictly a defense. The fact of the matter is I should have known that it was your property. I could also, in a case of a store, let's look at Walmart. Let's just use Walmart again. Walmart is a private corporation. It's a private store that people are invited into to shop. Okay, so it's something called invitation to treat in law. It's called an invitation to treat. So if I go up and walk into Walmart today, I can do that because the doors are open. Now, if I went up 12 o'clock at night when everything is locked up and I walked in there, I would be trespassing. Today, when I go in and I open and they're open to me, I am strictly not trespassing in their store until they tell me to leave. If they told me that I was not welcome in Walmart anymore because I got caught with a pocket full of candy, I would be trespassing. Even though the doors of the stores are open and these sorts of things, I've been told not to come in. So if permission were revoked, the person must be given the opportunity to leave. If refused, one may inject using only reasonable force. So they can't throw me out, but they had to ask me to leave. Okay. Now, the duty to trespassers is minimal. What does that mean? Well, it means that if you're the landowner of your Walmart or if you own a piece of land, you don't owe any particular duty to those people. But if they're children, you could say you do owe a duty. Now, this owing a duty to trespassers has occurred and tragically has occurred several times in our country and several times around here in the last number of years. There was a case of a young man who was riding his motorcycle there a few years back, or a motorbike, and he ended up going on to private property, but in the process, he drove through a chain link fence, and the chain went across and killed him. Okay, so basically he drove into the chain link fence. Now, was he supposed to be on that land? No. Would the people that own that land be not guilty or have no problem? No, they wouldn't. You need to make sure that you don't potentially hurt someone, okay? What we mean by the minimal duty is, yeah, you don't owe them any particular duty, but you do owe them a duty not to hurt them. So you can't build booby traps or dangerous fences or something.
Or at least make the fence like very visible.
Yes. You've got to do everything you can to ensure that the reasonable person, again, we got a lot of this reasonable person in tort. What would a reasonable person do? Okay. And the reasonable person test really has to be met. Is it reasonable to put these things up or, to shoot someone, for example? And if it's not reasonable, then that person, the person who owns the land that's being trespassed on, would certainly be held accountable. The only real defense that a trespasser has, and this can happen, where the intruder had no control over where he or she was. I always think about jumping out of an airplane. Well, I don't know why anyone would jump out of a perfectly good airplane, but a lot of people parachute, right? So you could parachute out of an airplane, and sometimes you come down in places that you're not thinking that you should land. So you could land, let's say, for example, in a farmer's field that's gated off, okay? You could argue that, you are trespassing. You ended up landing on the land that a farmer, it's gated. There's all kinds of signs around saying don't enter and all this sort of stuff. You still ended up there, but you really had no control over it. So you could potentially argue, and this is a potential defense as opposed to a certain defense, that you were accidentally on their property through no fault of your own. Now, if you're driving a car and it slips on ice and you ended up sliding into someone's house or someone's property, you know, that same sort of thing would possibly be a potential defense, that you had no control over where you ended up. You would probably still be, responsible for any damages that you take. Okay, just the last one for today then. I'm just checking where I am in terms of time. We've got this nuisance issue. And the nuisance issue is something that rears its ugly head a lot with regards to tort. And there's basically variations in nuisances. A private nuisance occurs when one uses his or her property in such a way as to substantially interfere with your neighbor's use of his or her own property. So I have my property here, and let's assume my neighbor next door always blasted The Who. This is a bit of a true story here. So Teenage Wasteland was coming over my fence at 100 decibels all day, all night, driving me cracked. Okay? That would be considered a private nuisance because in my property, I have a reasonable right to be able to enjoy it without too much interference. Now, the court will argue to say, well, it was an extended period of time. Was it ongoing? Was it in the middle of the day? Was it in the middle of the night? These sorts of things would come into to kind of evaluate how much of a nuisance it was. But if it went on 24 hours a day, 7 days a week, that would certainly be a nuisance. And here's the refinery. We talked about the refinery. The offending use must be an inappropriate use for the property. Now, this is a problem that we have in town a lot. An inappropriate use of the property. If I got an oil refinery and I got it set up, I would expect that an oil refinery is going to make noise. It's going to emit smells, these sorts of things. And, that would be considered an appropriate use of the property. My neighbor's house with Teenage Wasteland blaring out 24 hours a day would not be considered an appropriate use of the property. So you really need to think, what am I next to? What is an appropriate use? A lot of people in St. John's, for example, have had some concerns with Wendy's, McDonald's, Tim Hortons right next to them or in their backyards, right? The fact of the matter is, if the region is zoned, if the area is zoned, if you're in a city or a municipality, our municipality here in Clareville, for example, is split up into what we call zones. And there's zones that are residential, there's zones that are commercial, there's zones that are mixed use. You and I probably live in a residential zone, meaning we can't put a plant, an operation in your neighborhood. You can't do that. Now, we do have industrial zones in Clareville. For example, the industrial park up there off by Don Cherry's. That's an industrial park. You would assume that an industrial park would have some degree of noise coming out of it. If you bought a property in the industrial park, you have to accept that that is an appropriate use for that property. So nuisance is really depending on where you are and what kind of level it is and the volume of it. And what you're going to be looking for in terms of damages, if you sue someone for nuisance, is damages in terms of dollars and cents. But most likely, what you're going to get is something called an injunction, which is a please stop doing that offender. The court is going to say, you can't do that anymore. You can't play the loud music. You can't make that noxious smell. You can't burn your garbage, these sorts of things. And in most cases, an injunction is the best you're going to get out of a nuisance to stop someone from doing it. Let's see where I am here now. Okay, I'm going to finish this off. In terms of defamation too, here's another interesting one, is where someone is defamed. So defamation involves the issuance of a derogatory or false statement to the detriment of a person, company, or product. So, as I say, there's two different types. There's libel and there's slander. Libel is written or broadcast. It has to be, if I write it down on a sheet of paper and nobody sees it, that's not what's considered libel. Libel involves me broadcasting it as well. Somehow or another, other people have to be able to see it. Okay? So I've write down that they're a nasty son of a gun. That has to be broadcast. The slander is spoken. And again, it too has to be broadcast. It's not as if I'm here muttering to myself and nobody's listening to me. You can't say that that's defamation. I have to broadcast it. Okay, now, to be defamation, the act must refer to the plaintiff and be published to a third party. So you have to name the name of the person that you're arguing against. That son of a gun is not adequate for referring to the plaintiff. You have to say that Paul Tilley. And it must be published to a third party. Now, this kind of rule is getting kind of weird in the age of social media, but effectively, it has to be communicated or broadcast somehow. So published to a third party could be television, radio, newspaper, internet, these sorts of things. And if you do it by mistake, that's not really a defense. The fact of the matter is you did slander or libel someone. Now, the question is, it involves the issuance of a derogatory and false statement. The statement has to be false in order for it to be defamation. If I say something about someone that's absolutely true and can be proven to be true, it's not defamation. Okay? So, in terms of the defenses for defamation, and there are a lot of them, justification is the primary defense. That person is a thief. If they're end up in jail, if they've been proven guilty in court and I say that person's a thief, and the court has borne it out, that person is a thief, you can't, it's not libel, it's not slander. We also got substantially true. I have to prove that there is mostly truth to it. Maybe I got one aspect of it wrong. Again, I'm splitting hairs here, and the court's going to say that will limit the amount of damage to me if I'm the one doing the defaming. Couple of interesting issues here is dealing with privilege. Privilege is important in our society, and absolute privilege is a very important one. If I speak or say or write something, I can be held liable for it. But if I'm a parliamentarian, if I'm a member of parliament, a member of the legislature, and I say something on the floor of the House of Commons or on the floor of the provincial legislature, I cannot be sued for that. Because I have what's called absolute privilege. And the reason for that is that in order to have all information available in a decision-making body, such as legislature, people should be able to be free to speak their minds. That's the basic theory behind it coming out of the Constitution. As a result, members of Parliament and members of the House of Assembly who speak on the floor cannot be held for defamation. Some organizations have what's called qualified privilege. A qualified privilege, it depends on the job you're in. If a statement made pursuant to a duty, let's assume that you're a police officer and you have a duty to relay information along. It's your job to do that, so you cannot be sued for it. It's allowed if a person made a statement, thought it was true, made a statement without malice, and only communicated to those who need to know. So again, we're running into splitting hairs here. You know, if the damage was minimal because of these factors, then you could argue that's a defense. Now, here's one for the news media. And this is important for us as a society, something called fair comment and responsible communication. The news media are often sued for saying stuff that the person didn't like, the person who was spoken ill of, you know, oh, I don't know, the premier screwed up or something like that. The media, in its defense, will use this thing called fair comment, which means that it is in the interest of society for the media to do its job and to hold people to account. So as a result, the media are covered under this defense of fair comment. So years ago, people like Ray Guy or Rex Murphy or these commentators that are few and far between now in our world, they can express an opinion about public figures. You know, Donald Trump's an idiot, works, etc. Muskrat Falls is a disaster. As long as it's based on some reasonable degree of facts and not made with malice, they can argue that, yeah, we're not libeling or slandering someone because of that. And we also have this last one, which is called responsible communication. It protects the media if reasonable diligence is used to verify the facts. So as long as they've checked their sources, reasonable. So these last couple are really designed for the media and to protect the media from being dragged off to court every time they write something or say something. Okay, I know I'm running out of time. That's as far as I'm going to go today.